So in terms of the exam review, what I'd like to do is actually walk you through the exam question one part at a time. If you want to follow along with your paper, you're welcome to, or if you want to look on the screen, there's not much behind me, but I want to walk you through. What I want to do is show you how I would read the question were I a student in your shoes. And there's a specific way that I approach these exams, which you may or may not take. It's, it's entirely your call. But I suggest that you do this because I wrote the exam, and you should do it the way I want you to. But again, you're welcome to disregard my advice. Actually, I joked in my proper review that I should write on the board a hint over here, just to screw with people at home. But I'm a nice guy, so I won't do that. So the first thing that you should do is know the basic rules. Okay, 1,000 words per question, 2,000 words total. Please do a word count, not a character count, and you'll be in good shape. Once you get that much, you should immediately read the instructions. And the reason why you should read the instructions is I invariably will give you different hints and clues about what to do. So it says, okay, the year is 1960. All right. I've mentioned this several times, but on my on my exams, there's two types of questions. One is in the present day. The second is at some period in time, whenever it is. Could be 5 years ago, could be 10 years ago, could be 100 years ago, whatever it is. And the reason why I situate you in the past is I want to see that you understand how doctrine is developed. It's not enough to tell me, here's the black letter law in 2015. I want to know, how did the law stand in 1960? And it's in this place that a commercial outline will not do you any good. In fact, it'll probably harm you because they're not written to help you with these questions, and the reason why I ask it in the manner I do. So the question says the year is 1960. It's the waning days of the Eisenhower administration, 15 years after World War II, and there's some hostilities in Germany. So right after that, okay, there's some sort of executive power, war question, whatever. So in the present, takes some executive actions to counter these threats. The House of Representatives votes to impeach him. I think I've had like at least 2 or 3 exam questions involving impeachment of a president. So that's actually, I like asking about that. And the reason why I ask that is because there's no courts, right? There's no issues of political question. There's no issue of whether the court should get involved. This is a purely constitutional issue, which is why I asked that. So in this case, you're advising the Attorney General, and you're defending the president during the impeachment trial. Okay. After you read that little paragraph of instruction, I'd recommend you jump down to the actual prompts. It's on page 3. These are the 5 questions that I want you, I'm sorry, on page 4. These are the 5 questions that I want you to answer. And I suggest you read these first. And the reason why is I'm telling you what issues I want you to spot. I'm telling you, right? If I were to make this exam very difficult, what I would do is give you this fact pattern and say, discuss all relevant legal issues, period. Yeah, and then it's up to you. I'm not doing that for a host of reasons, but one of which, it makes it very difficult to grade because everyone goes in every which direction, and it's very hard to compare paper A to paper B. Here, I'm giving you 5 issues. It makes my grading really easy. Why? The question's worth 50 points. There are 5 parts. Each part is worth 10 points. I can score each question on the scale of 1 to 10. It makes my life really easy, really easy. And I can compare, okay, here's student A, here's student B. They both answer the same issue. They each have, roughly 200 words. Go. This makes it, in my mind at least, extremely fair, or at least as fair as grading can be. It's a funny story. Former President Clinton taught law school at the University of Arkansas. He taught constitutional law. He wasn't president yet, but he was still in private practice in Arkansas when he was Attorney General. And he was teaching ConLaw, and he lost his students' papers. No idea where they were. And there's an old joke, throw the paper down the stairs, however they fall, that's the curve. But I think there's a little bit more fair. So it says here, your advisor to the Attorney General, write a memo of 1,000 words, citing all relevant Supreme Court decisions. Again, decisions up until 1960, okay? I don't want you citing Noel Canning or Zivotofsky. Those haven't happened yet. Now, You're allowed to use the principles of cases that you've learned, but I don't want you straight up citing Zivotofsky or Noel Canning, whatever it is, because those cases are in the future. Every year, people do this. No matter how many times I tell them not to, don't do it. And then there are these 5 prompts. So the first one is Executive Order number 1 and involves waging war on the Nazi state without a declaration. Okay. And I say there, pay special attention to this 1941 declaration against the government of Germany. If I'm telling you to pay special attention to it, pay really special attention to it. This is a hint. I'm trying to help you. Occasionally, I'll write a question that's really hard. I'm like, oh man, that's too hard. So I'll put a little hint in there to get you in the right direction. Okay, don't ignore these hints. Okay, question 2 says the second article of impeachment, deny equal protection of the laws to white males. Well, you have to ask yourself, 1960, what was the equal protection case law like? Well, we had Korematsu, Brown had just been decided a couple years earlier, so you have some cases you can work with. Question number 3, failing to execute the laws. This one probably is not entirely fair because I didn't really cover this as much as I did last year, but I think I'll explain more later. Actually, I took it out this year because I wanted to cover Zivotofsky, which hadn't been decided last year. But for the spring, I'm shrinking Zivotofsky. I'm doing an entire section on the take care clause because effective yesterday, the Supreme Court will hear the immigration case this year. I was following this one very closely. I've written extensively about it. So the second the court did that, I'm like, okay, let me add this to the syllabus. Yeah, I changed stuff. But so you guys didn't have that. So if you couldn't answer 3 too much, it's okay. Number 4, what was the strongest defense of recess appointments? Okay, this is Noel Canning, which had been decided last year when I taught it, but we don't know Noel Canning's the name of the case yet. And then number 5. I often want you to do policy, and this question I do so explicitly, right? From a policy perspective, how does a president's authority of discretion matter? Okay, and this is where I want to see if you've actually been paying attention in class. This is not, do you remember the facts of the case, or do you know the black letter law? This shows me that you've actually thought about these issues. You've paid attention to our class discussions. You've listened to what I've said. You've listened to what your colleagues have said. And invariably, this is a kind of question that gets you to the A. I often say it this way. If you give me the what is the law, how did the court rule, that'll get you a B. And if you're happy with a B, go for it, right? But if you want the A, you got to tell me the why. Why is this the rule? Why does it work this way, right? Is this a good rule? Is this a bad rule? The why is what makes a good legal analysis. The what, anyone can do. Any first-year law student can do that. But differentiate yourself. Show me that you've embraced this material, and you'll be on your way. I know at the end, to make this abundantly clear, this is an impeachment trial. This is not a trial in a court of law. Therefore, we don't worry about standing or justiciability or a political question. None of this matters. And that's why I like asking about impeachment, because it's a clean issue. You can't say, oh, that's a political question. No, that's a cop-out. This is how I go for it. All right, so let's go up to number 1. I'm sorry, back up to the first paragraph. And I want to read through this paragraph by paragraph, and I want to show you how long reading the question ought to take you. In my mind, if you have 90 minutes for this question, give it 30 minutes to read the question really carefully. And I'll give you one hint. Now, I've just told you 1 through 5, what are the 5 issues? As you read through the fact pattern, put a little number in the margin. Oh, this is for number 3. Oh, yeah, this is about the response. This is number 2, right? Oh, this is about waging war. I'll put a little number 1. If you do this, you already marked up your exam so that when you're outlining your answer, you can say, oh, do 1, 3, 5. Pull the relevant facts. It will save you from having to read the question a second or third time, right? If you put the little numbers in the margin, you save yourself the hassle of having to go through the question again and again and again and again and again. Okay, everyone with me so far? Okay, so it says here again, in case you weren't paying attention the first time, the year is 1950. Why is this, I'm sorry, 1960. Why is this, sorry, 1960. Why is this relevant? World War II ended 1945. Okay. This is where things get a little, I'm making up history, but it's actually grounded in kind of real stuff. So at the end of the war, the German government, the National Socialist German Workers' Party, commonly known as the Nazis, they were removed from power. Hitler, the government's chancellor, was dead. Okay, why am I telling you this? Okay, the U.S. and Soviet Union divide the country into two: West Germany and the West, democratic, and then the communist East Germany. And as you know, Berlin is a city in the middle. It was divided by a wall. The wall wasn't built till, I think, 61 or so. So I'm making up a little bit, but it's close enough. And new governments are formed in each nation. Right? Why am I giving you all this history of German politics? So why am I doing this? Because the question you will recall from the first one is the war was waged against this Nazi state. Which government are we waging war against? So here you have a situation where there was a government, the Nazis, they split in half, this country, that country. I'm trying to mix stuff up, and it's alluding to ISIS, which last semester was spanking new, but here it's a little bit older. So, but not everyone accepted the cessation of hostilities. Followers of Adolf Hitler's legacy plotted to reunify the fatherland as a new nation called the Nazi state. If that isn't clear to you, it should have been from the class discussion. That is effectively ISIS. And indeed, even the Islamic State, Nazi state, I tried to make that really obvious. But I think in one of the readings, I mentioned this in class, under the current military action against the Islamic State, the president has relied on something called the 2002 authorization for use of military force against, 2001 authorization against Al-Qaeda. Now, is Al-Qaeda ISIS? No, they hate each other. They're actually at war. They're fighting with the bigger terrorist group, right? But what the U.S. government has actually said, and this is actually a verbatim quote, is that the Islamic State is the true inheritor of Osama bin Laden's legacy. That is, when bin Laden died, ISIS inherited their legacy. Fee simple, I suppose, right? Property, yeah. So ISIS inherited the legacy. This is actually their verbatim quote. So what the government's argued now is that, in fact, ISIS is Al-Qaeda. And that's what I was getting. I think if I didn't mention that in class, I did last year. So this is why I write the exam questions new every year, because it's always based on whatever I talk about, and it's always perfect. So, okay, so they inherited this legacy called the Nazi state. So in 1960, on the 15th anniversary of VE Day, Victory in Europe Day, there's a lot of good history in there, so you'll learn a thing or two. I love writing these questions. Nazi militants conquered Berlin. They reunified the city, and they raised the flag over the Reichstag, that is the German Capitol building, and they assumed control of the nation. So what happened? There were two nations. Now there's one. It's called the Nazi state. What is it? Now, this is also an important point. I say the Nazi state, unlike Hitler's Nazis, don't have any aggression towards the United States. They don't seek world domination. Their goal is to reunify Germany. Why is this relevant? Because when you get to later, the authorization of force against Germany from World War II was because they were trying to attack us. It occurred slightly after Pearl Harbor. So here you have a different state that doesn't pose any sort of imminent threat to the U.S. Okay, so that day, the Secretary of Defense informs President Eisenhower about the coup in Germany. Eisenhower was the Supreme Allied Commander, 5-star general. He's worried. And Eisenhower was afraid that the Nazi state will advance on a small Jewish village on top of a mountain where they're going to murder all the residents. If you recall, last summer, or I guess summer of 2014, before we attacked ISIS, was actually a mountain with a bunch of, was it Kurds? Or Yazidis, I can't remember. Yeah, it was a mountain, and there's a village in the Yazidis, which is an ethnic minority in Syria, and basically ISIS was about to basically siege the mountain and kill them. Right? This was, I probably mentioned it last semester. I didn't this one, but there was some sort of imminent, genocide that was about to happen. 20 minutes later, Ike moves fast. Eisenhower issues an executive order, and it says action against the government of Germany. Now, pay close attention. Why did I say the government of Germany? Why did I not say the Nazi state? Right. Because the authorization of war from Roosevelt's days was phrased government of Germany. So you see what Ike's doing. He's trying to fit his military action into the framing of the issue from the World War II declaration. So he instructs the Air Force to attack the German government. No, it's not the Nazi state. the German government, drop bombs on the Reichstag, and to destroy the forces advancing on the Jewish village. No ground troops were engaged, and the bombing commenced immediately. This is effectively what happened with ISIS. The president just said, go bomb away. So President Eisenhower justified his decision to attack the Nazi state based on the declaration of war by Roosevelt in 1941 against, again, I'm really helping here, the government of Germany. I think I gave too many hints. I was being too nice last year. And this is the actual declaration of war signed by Franklin Roosevelt in 1941. See, December 7th, not even 4 days after Pearl Harbor. And it says, joint resolution declaring the state of war exists between, quote, the government of Germany and the government people of the United States. The government of Germany has formally declared war against the U.S. Therefore, it's resolved, the Senate and the House, that a state of war exists between the United States and Germany. The president's authorized to use all force to bring the conflict to a successful termination. Another fact which you probably maybe observed is I said the war ended 15 years ago with VE Day. Did this war end? Okay, the analog here is we actually declared victory against Iraq. The president pulled out. So can that same authorization against Iraq be used to continue? This is what I'm testing for. So President Eisenhower transmits the message to both houses of Congress, telling them about the executive order. The next day, the Democrat-controlled House, Ike was a Republican, not that it really matters, passes a resolution saying that the executive order was unconstitutional because the president didn't have the authority to wage war against the Nazi state. No, not the government of Germany, the Nazi state. And then the Republican-controlled Senate announces that no votes will be taken. Okay, what do we make from there? One house votes resolution saying that this is unlawful. The second one does nothing, yes, silence. And we've discussed at some length what the role of congressional silence is. All right, the following day, the president issues executive order number 2, creation of a spy program to infiltrate the Nazi state, okay? So to infiltrate the Nazi state, notice here it's Nazi state and not government of Germany. The U.S. will send spies to join the government and report on secret programs. And to ensure the spies look authentic and blend in, they have to be white males, blonde hair, blue eyes, Aryans, in other words, right? The president noted in his order that any agent sent to the Nazi state that didn't fit this description will be killed and tortured. Now, we've discussed, right? Is being blonde hair a suspect class? No. Is being blue-eyed a suspect class? No. But is being white? Well, yeah, that's a racial classification. And we have brown. Brown was decided. So I actually want you to think about here is Korematsu, again, was good law. I mean, it's technically still good law. Does a state have a compelling enough interest to use race as a classification with a spy program? If we take it for granted, or we take it as true that any non-white spy will be tortured and killed because they don't blend in, does a state have a good enough national security reason to impose a racial classification as a means of saving the United States' national security? I tend to think the answer to this one is yes. I mean, as odious as racial classifications are, I mean, Grutter hadn't been decided yet, but if educational diversity suffices, then I think this would probably, suffice. But I'd accept an answer both ways. Okay. Next. Okay. Now we have executive order number 3, halting immigration from the Nazi state. And again, this was a play on the immigration case, which I didn't talk about with you guys too much. And it says in 1955, Congress passed an immigration law that capped at 100,000 the number of visas available annually to immigrants from West and East Germany. No, those countries may not even exist anymore. We haven't recognized this new Nazi state. So through executive order number 3, the president determined that even though Congress gave him the discretion to issue up to 100,000 visas and gave him the money to fund those, he would issue 0 visas. So this is basically the opposite of what's going on now, right? Instead of admitting too many people, he admits no one. So Congress said you can admit up to 100,000. President says, nope, 0. He insisted that the U.S. would not admit any immigrants to the Nazi state, even Jewish refugees seeking asylum to the Nazi state. I don't know how prescient I was, just substitute Nazi state in Syria. I think I was about 6 months ahead of the curve on this one. I don't know if you saw, but about 4 hours ago, Texas actually filed a a lawsuit against the federal government seeking to stop the resettling of Syrian refugees in Dallas. The Syrian refugees are coming, were supposed to be settled basically tomorrow, or tomorrow or Friday, and Texas went to federal court in Dallas seeking what's called a temporary restraining order, an ex parte temporary restraining order, which basically means without even giving the government a chance to respond, the court can put this on hold till next week. The facts of the case are actually, I don't need to digress, but I can't help it. Can't. So the actual legal analysis is apparently there are several statutes, and I have not studied this closely. Don't take my word for it. I read the brief like an hour ago. So apparently there are a number of statutes that say the federal government is required to consult with the state governments before resettling refugees, and that hasn't happened. In fact, the federal government basically told Texas, we're not going to tell you what we're going to do. And on basis of that, the Attorney General of Texas filed this suit saying that until Texas has been consulted, until this law has been complied with, the federal government is acting illegally to resettle these refugees. So you'll know in the next day or two if the court will grant the TRO. But this this class never ends. So you'll hear about when you hear about it. All right, going back to the actual thing you want to hear about today, not what I want to yak about. Both houses of Congress passed resolutions saying that this order is unlawful. The president is not executing or not taking care of the laws being faithfully executed. He's disregarding the law. And this is a question of discretion, right? If Congress says you can you can admit up to 100,000 people, what if you admit 95,000 people or 50,000 people? Well, president's discretion who to admit, who not to. But if you do zero, you're just flatly refusing to ignore the law, is that in and of itself a violation of the take care clause? And I apologize, I probably mentioned it, but this wasn't, I spent a lot more time on it last year. So both questions from last year had stuff you didn't learn. This class fluctuates so much. I try getting a good question on the whole. Okay, the next paragraph. Okay, at 9 a.m. on May 13th, the Secretary of State resigns. He says this order is unconstitutional. He won't enforce it. An hour later, the president nominates Adlai Stevenson. He was the famous ambassador to the United Nations. He ran for president a couple times. No, he was never president. Yeah, he thought he was. So he nominates Adlai Stevenson as new Secretary of State. Okay. The Senate Majority Leader says the president he will not bring this guy for a vote until the executive order is revoked. Okay. So then at noon, the president goes for the 1 hour lunch, a 2 hour martini lunch, if you will, in Madman days. And during the break, the president announces that he has appointed Stevenson using the recent appointment power, citing the urgency of national security and the fact that the Senate refused to hold a vote. So those two facts are important, right? It's not just that he picked a 2 hour window, or 1 hour window with to make the recent appointment. He said, listen, we had a national crisis. I need a Secretary of State to deal with this immigration. We're having a war with these other countries, diplomatic stuff. Oh, and by the way, the Senate refused to hold a vote. Gridlock, intransigence, right? These are things we developed, right? Is that in any respect a role that gives the president the license to take these actions? Okay.
Can we ask a question?
Of course you can ask a question. Sorry, I've been talking. If you have a question, raise your hand.
Would it have been okay? I mean, though I can't talk about Zivotofsky, obviously, but could we have said that at this time it never had been defined what exactly was the minimum of a recess or defined?
You mean Noel Canning?
Pardon me?
You mean Noel Canning, not Zivotofsky. Noel Canning was a recess case.
Okay.
That's okay.
Yeah. I mean, even though that hadn't happened,
the court has never defined how long the break must be for it to trigger the recess clause. That's absolutely a valid statement of law.
Okay.
Absolutely. Yeah, no, that's exactly right. In fact, the court hadn't.
Okay.
All right. So then it says on May 20th, the House approves 4 articles of impeachment against the president. So just so you know, you should know this, but impeachment is voted on the House. You need a majority. Then it goes to the Senate. You need 2/3 for removal. Okay. And these are I actually copy these in part from the impeachment articles against Bill Clinton and Andrew Johnson, just so I get the framing correct. I do a lot of research for these. I think the first one's almost verbatim, or I think the third one's almost verbatim from the impeachment against Andrew Johnson. with his failure to enforce Reconstruction. So Article 1 of the impeachment is he waged war in the Nazi state without a declaration of war. Again, notice, not government of Germany, Nazi state. Number 2, his executive order number 2 denied equal protection of laws and discriminating on the basis of race and, oh, I forgot gender. I didn't even mention, yeah, so white males. But in 1960, there was no gender jurisprudence. It was a rational basis. There was an intermediate, hadn't happened yet. Number 3, he failed to take care of the laws faithfully executed. You will be hearing a lot about this in the next 4 months because the Supreme Court's going to take this case in probably March. My spring just got a lot more crazy. I was really hoping they wouldn't take it, but well. Number 4, the president made the recess appointment in violation of the recess clause. Wherefore, President Eisenhower should be removed from office. And there's an impeachment trial to be presided over by Chief Justice Earl Warren. As you know, when the president's being impeached, the Chief Justice sits. In fact, that's the only job he has in the Constitution. Okay, so then we go back to the questions. So read them a second time. So we have number 1, what's the strongest defense? Again, you're defending the president. The strongest defense, the first article of impeachment, charging with waging war against a Nazi state. So what I really want you to do is think about the authorization against Germany. And it's a muddy fact pattern. Can the president rely on the authorization against Germany to go against a Nazi state? Number 2, is the spy program a denial of equal protection because it's limited to white males? You got gender and race going on there. Number 3, what about the take care clause? And again, if you didn't know this one, it's okay, but I'll go over it anyway. And number 4, what is the strongest defense that the recess appointment violate Article 2, Section 2? And then finally, number 5 is a policy question. What role does discretion play? You know, what is the president's obligations for protecting national security when Congress won't vote on his agenda? This was the issue last year because the president wanted an ISIS declaration. Congress wouldn't give it to him. All right. So any questions about the question itself? I'll get to the what do you call it? The answer, the A+ answer in a moment. Any questions on the question? Yes. Yes. Oh, I'm drawing an analogy. I'm trying to use the facts of today. Well, I mean, we talked about ISIS in class. When you're reading this, you should think, oh, wow, this is similar to the ISIS question, right? I'll often make my exams based on current events, even if it's set way in the past. You don't have to mention, the word ISIS should not appear in your answer, but you at least be aware of what's going on. Well after. Other questions? Yeah? Are you handing or no? No questions? Let's move on to the A+. You all have the A+ answer, right? Okay, good. All right, so one thing before I start is the A+ answer is not perfect. Let me explain. I've never given 100 on any exam I've ever given. The highest anyone ever got, I think, was maybe a 95 or 96. And I can't remember if that was property or ConLaw, but I think that was property. So even the A+ paper is not perfect. You will spot things that you don't like, things that maybe could have been said better. Fine. On this one, I don't remember exactly. I think maybe low 90s was the A+. So again, there are points that are missed. So don't pretend that this is some sort of gospel gold standard. It isn't. And invariably, whenever I go back and read, I'm like, oh, wow, he screwed that up. And no, he should have said that. But it's when you read all 75 papers at one, you can compare one to the other. So it's always easy to pick these apart after the fact. So question number 1. Okay, so what's the leading case? Well, we have Youngstown. Youngstown was decided a number of years earlier. The president's acting inconsistent with congressional intent. He's at the lowest ebb. There's a presumption of constitutionality. The president's action may still be justified fits within his Article 2 powers. Okay, how so? Even if the president's only acting with Article 2 powers, they're broad enough to allow for foreign discretion. Curtis Wright, sole organ. You guys know this. Zivotofsky came after the fact, and you should know that in light of Zivotofsky, Curtis Wright probably isn't good law. They said that was a dictum, if you can believe it. But again, last semester, this was good law. This is why this class changes every semester. The student also wrote, the Constitution recognizes not only the powers in war, but the need to act unhindered. The president, commander-in-chief, can declare war. He also said it's a declarative power. Okay. This is demonstrated by the declaration of war by Roosevelt. Again, this one didn't exactly nail what I wanted to, but what I really would have wanted the person to say is the declaration against Germany in 1941 should be construed as the equivalent to authorization against the Nazi state, that they're effectively the inheritors of Adolf Hitler's legacy, right? That's like the perfect answer. Yeah, so this person didn't get a lot. I mean, this is probably, if I had to guess, 8 out of 10. 8 out of 10. Good answer, but he didn't get exactly what I wanted. And look, you can still get an 8, and it went up with an A+, because I think the other ones may have been better. Okay. Any questions on number 1 or things that you want to ask about? Please.
So if it is good law at the time, do you want us to name the case? And if it's something
That's a trick question. So it's 75 years later, Curtis Wright was deemed no longer a good law. Yeah, I think it'll be okay if you decide Curtis Wright here. At that point, had not been obviated, had not been basis.
Or that, or as long as we just talk about that.
Yeah.
Okay?
Yeah.
Okay.
No, I mean, so it's actually a very interesting question, because at the time when Curtis Wright was written, for decades, law professors said this can't possibly be current law. This can't possibly be correct. And it wasn't until Zivotofsky in 2014 the court said, oh yeah, that was a dicta. So, but you know, the executive branch had been citing it for 75 years or whatever it is, whatever it's been. Okay. Number 2. Okay, it says here the president may discriminate based on race and gender because he's acting to protect national security. All right, what does he say? So under Bowling, again, it's actually not Brown, it's Bowling v. Sharp, because that's the Fifth Amendment equal protection case. I mean, actually, in the 14th Amendment, so that was actually good. This incorporated the decision under Brown. Good. That race violates the protection clause. However, Brown was based on educational interest, so it's unclear if discrimination is banned in all cases. Korematsu, which again, you may not be comfortable citing Korematsu, but if you're defending the president against impeachment, then yeah, you're going to cite Korematsu. The government may discriminate for national security interests. Here, he's trying to protect America. This mirrors the interest at issue in Korematsu, choosing white men as spies who infiltrate the army, right? And then you go to narrow tailoring, right? Could you make this classification more narrowly tailored, saying, oh, not just white men, but you know, any type of man? Well, if you do that, they'll be killed. If you made an exception, these people will be executed. And the student exercises, in the last sentence, they've not yet recognized gender as a quasi-protected class, so it's a rational basis review. There's nothing there. This is probably like a 9 or maybe even a 10 answer. I mean, this hits just about everything I want to hit. Any questions on number 2? No?
Actually, I do have a question.
Yes.
So I couldn't help but notice, actually, I apologize, going back to question number 1.
That's okay.
It actually starts off, and you're very clear, what is the president's strongest defense?
Mm-hmm.
But yet he did bring in how, in a sense, an argument against the president. So, I mean, which is saying that the argument against the president actually came from Youngstown.
Yeah, that's why I said it's probably about a B.
Okay,
yeah,
so
yeah.
Actually, that's what I say.
I mean, the
start
first
off-
one isn't actually that strong. I mean, maybe a 7 or maybe 7. I don't know. I forgot what I scored of it, but it's probably an 8 because it was pretty thorough. But again, to get to the A, the 10, the 9, 10, you have to do the Y. You know, actually get what I'm really asking. Yeah, again, this is why I love by saying these questions are not going to be perfect. It's also conceivable that his number 2 is strong as number 1, and you know, balanced out. So it's always hard, but I think, Michelle, you're on the right path. All right, let me go on to number 3. Again, if you didn't get this one right, that's fine, because in fairness, I didn't really spend too much time on this issue. I will next semester. So first, the immigration law which Congress passed was allowing discretion, okay? If you notice, it said up to 100,000. To say exact 100,000, up to 100,000. There's no mention of a minimum number. So the president's acting within the discretion granted by Congress, and he's executing the laws on that basis. And here he actually worked in Zivotofsky, which hadn't yet been decided by him. I think I mentioned it, at least in class. The recognition dues of foreign countries, right? In terms of accepting immigrants, this is within the president's Article 2 powers. By denying foreign immigrants, the president's exercising constitutional powers. Third, again, he cites or he or she cites Curtis Wright again, and he actually analogizes halting exports of guns with halting imports of people. I thought that was actually a pretty clever argument. Make an argument, impress me. Because one of the things I do is if you come up with something that I don't, which happens every year, I give you points for that. It's like, wow, I didn't think of that. Because I try to think through all the different answers when I'm writing this, but invariably, a good paper thinks of things I didn't. And then the last, oh God, as the Americans sending spies to Germany, Germany might send troops to America in the form of immigrants, Syrian refugee. This is way ahead of the curve. The president may need, in bad faith, to ignore the laws to protect the people during times of war. This is the in times of war, the laws fall silent, which students love quoting. But it's not an unreasonable argument for an impeachment trial to be made. Okay. Any questions on number 3? And again, I apologize. I didn't really cover this, so it's a little bit unfair to ask you to write this one. But I think I like the exam a little. Michelle?
Yeah, does it help us to get points where I actually brought in where Thomas Jefferson said sometimes you have to ignore the law.
Yeah, that is Thomas Jefferson, isn't it?
Yeah.
When did he say that? Do you remember?
Yeah, I had it. Yeah, sometimes it says ignoring the law helps to secure the law. It was during the Louisiana Purchase.
Exactly. Remember that. The Constitution makes very clear that Congress has to pass laws to acquire territory. It's a property clause. And Jefferson had basically made the decision, I'm going to do this myself. He had sent his expedition, his emissaries, and they said, listen, we got this deal. King Louis is going to sell. So Jefferson said, go for it. Subsequently, Congress ratified it, but Jefferson said, listen, we needed to do this. It was necessary for the nation. Even though I don't have the power, I'm going to do it anyway. I think that's a very fair precedent to rely on.
Okay. Even though it wasn't necessarily a case,
this is
doing stuff like that.
Like, okay. With executive power, we don't have a lot of precedent. So if you want to cite what Jefferson, right? Dude, cite that. Is that my cup? No, it's not my cup. I don't know, but I lost my cup. I had a South Texas one. I have no idea where it went, so I had to buy a new one. I'd had it for 3 years. No idea where. Any other questions on 3? Or if I do like Steph Curry like this, 3. Number 4. So this was a question about the recess appointments. This was Noel Canning. So the student wrote, the president the right to make appointments and recess appointments. The appointment was made during in-trust session. Yeah, good to you if you know between in-trust session and inter session. This is an in-trust session. Again, the clause, and one thing I like, the student wrote first, second, third. Do this. It makes my life easier. I can see that you're actually building an argument, right? You use numbers or words. I don't really care. The clause doesn't specify whether the appointment must be made during inter session. That's correct. There was a break in the session where the senators went to lunch, which would be an internal break. Good. Second, the appointment was made without the approval. Okay, well, again, recess clauses don't require Senate approval. Third, even if this was a bad faith appointment by the president, this was only response to bad faith by the Senate. Again, this is an interesting argument, right? I think the student did a clever argument here saying, listen, the president did this out of necessity. Had the Senate taken a vote on this emergency issue instead of going to lunch, right, he would not have been put in this position. And you can imagine if this was actually an impeachment trial, this is what the president's going to say. The majority leader refused to give advice or consent to the Senate till the order was revoked. And again, the president says, this order was part of my executive power. Why would I have to revoke something in my sole power? And fourth, the student writes, this was an emergency. There's national security issues. You need this cabinet level official, Secretary of State, to help deal with the immigrants, the recognition of foreign nations. So when the student wrote, for the national security, the president may circumvent normal procedures. That's an audacious claim, but I think, again, this is you're trying to defend the president in an impeachment trial, right? If he doesn't have a Secretary of State, how is he supposed to make diplomacy and deal with immigrants and everything else? So I thought this was almost certainly a 10. If it wasn't, I'd go back and surprise it. I think it was probably almost a perfectly a 10 answer. Okay. Any questions on the fourth one? Anything? You guys are quiet. Only 10 of you, though. So, all right, let's go on to number 5. This was, again, the policy question, right? What is the president's role of discretion? And the student wrote, the judicial and the legislative branch have many members to ensure our representative opinion of the populace. These inefficiencies are valuable, blah, blah. Okay, Federalist 10. If you can actually meaningfully cite a Federalist, you should do so. It's always good. Don't just like mention Federalist 10 without any relevance. Like every year somewhere, it's like, ambition must check ambition. It has absolutely nothing to do with what the answer is about. They just throw it in there because they remember I like that phrase. But if you actually work it in a meaningful sense, it's a good idea. But don't just throw it in randomly. People do that every year. It's like, yes, I know, men were angels. Okay. As stated in Federalist 10, the dangers of factions must be guarded against, the influence of a few and confusion of the multitude. And basically, when you have all these powers checking, factions can be dissipated. The Constitution functions under a unitary executive. That's one theory. There are occasions when the nation might act swiftly in response to a legitimate threat. Lincoln, if you remember the Gettys, the Emancipation Proclamation seized the property of slave owners, but this was done to protect civil rights. Unclear if he could do that. Unclear if he had the power to do that. Roosevelt made sweeping changes that crippled the nation. I'm sorry, which aided the crippled nation. Little Freudian slip there. Everyone knows, but by the way, so Roosevelt's policies extended the Great Depression. This is a common myth. Roosevelt's policies, the reason why it was so great was because of his policies. By expending so much money and creating these massive programs that took things away from the private sector, he actually prolonged the Depression. His agricultural programs, like in Wickard, disastrous. So anyway, Freudian slip. FDR made sweeping changes which aided the crippled nation. Oh, I just realized he wrote crippled and FDR in the same sentence. I hope that wasn't deliberate. But this was only possible when the court recognized the president's broadened role during times of national hardship. And again, you may recall the case Home Building Association versus Blaisdell. That was the Contracts Clause case, where basically the government suspended all foreclosures. And a claim was brought this violated the Contracts Clause. And the court said, listen, we have a national emergency. People are getting thrown out of their homes in this depression. We're just going to ignore the Contracts Clause for now. So there is actually case law that in times of hardship, the president's, or in that case, the state's powers are allowed to violate the Constitution. And again, the last sentence, I think, is a strong one. During the war, the president may be required to make unpopular and potentially unconstitutional decisions. Yet this discretion is necessary for the protection of the people. And I think, that's your closing statement, right? It's like he didn't do this to aggrandize his power. He goes on his way out. His term was over in a couple months. He did this to save the American people. You're going to throw him out of office now after all that he's done? And I think that was probably a 9 or something. That was a good answer. Maybe even a 10. Probably 9, if I had to guess. Okay. Questions at number 5.
It's not a question.
Yes. Question. I'll do questions on anything in a minute. But anyone question number 5? Michelle?
Yeah. So 5, though, about being a social policy, something I brought up was that I thought this was more about actually a constitutional crisis.
Ooh, I like that.
And so that's what more I went on about. Here, Congress is really standing in the way of the president, and going further with what it's doing just creates more. Would set a precedent where then the next time there's some state of emergency, the president may be very, very cautious and maybe put the country in more jeopardy. I just thought it had ramifications with all these hurdles or actually blockades that Congress was putting in front of the president.
Mm-hmm.
And not only that, secondly, I got into the whole thing about completely undermining a president. So the power, you want to keep that separation of power. You want to keep the power to the president in a sense, and then now you're diminishing it. I think it then makes an imbalance and Congress becomes too powerful.
So the president's trying to recalibrate it or readjust.
In his defense, that get into this.
Yeah, and that's the chicken and the egg, right? Who was the bad egg first, right? And who gets to fix it? But yeah, I think those are both fair points.
Because I think there are ways to solve. Congress could have solved some of these issues, especially even with Adlai Stevenson. It could have said, the president could have said in this emergency, okay, well then pull to ask him to step down in that time of emergency if they really thought he was the wrong person at the time, okay, and not for political reasons maybe. Say, ask the president, okay, renominate somebody else if they really
but once the guy's nominated, Congress has no say short of impeachment.
I know, but I'm just saying the president could have always said, I did this in time of, I had to get somebody. is the only guy who would take the
Right.
job at the moment. And that, I'm just
And
saying, there
this-
were ways to cure it after the fact versus going after an impeachment, which I think would
Well,
tear the
that's
nation
why I
apart.
wrote the question the way I did. I'm trying to have the most belligerent, resolution conceivable.
So I took it a little different way
Yeah.
about being a constitutional
Daryl?
person.
Or the Labor Relations Board, they did that.
Yeah, well, actually, what happened in Old Canning, if you recall, is that even after the recent appointments were made, the Senate subsequently ratified those same people. And then it raised the question whether there were actions during that period where they were uncertain. That's actually being litigated now as well. But yeah, I think those are good points.
Okay.
All right, open up. So questions on other stuff?
So basing
Yes,
it
sir.
on the answer that we have here, and you may have already talked about this before, but is the test entirely essay?
Yeah,
Okay,
it's going to be exactly like it was last year and the year before.
I'm just making sure,
It's going to be 2 of these questions.
okay,
It's already done, already printed.
that's why I said you probably said something.
Yeah, no, I mean, every year it's the exact same format. No surprises. It's going to be 2 of these essay type questions. You have 3 hours, not 4 hours. One person thought that 4 hours was a 4-hour class. That's not the case. It's 3 hours. So just budget accordingly. Other questions?
Okay, I have a question, and y'all can all hit me on top of the head. Is
They would never do that.
Is Plus, just because it's been so long, I've been so stuck in property, is Plessy still good law?
Oh my, no.
When was it
No.
overturned? Okay, hold on.
Well, I mean, Brown didn't actually overturn
That's what I
Plessy.
read.
Brown did not actually overturn Plessy, but cases following Brown have basically made that precedent, have repudiated the precedent.
The only reason why, but I actually had it in here because in there it basically said that SCOTUS said a state could, make a distinction based on race.
That's Korematsu, not Plessy. Korematsu said you can use race if it's serving a compelling state interest, and there's no other way.
I was just
Plessy, the doctrine was of separate but equal. Korematsu did not say, well, you can have a Japanese camp here, you can have a white
Right.
camp there, right? That were the facts of that case. So Plessy is not good law, but Korematsu has never been explicitly
Yeah,
overruled.
right. Okay, so it's just the fact that I still had it that Plessy was still.
Well, in
It's never been
1956, after Brown did not overturn
overturned.
Plessy.
I know that.
What it said was the doctrine of separate but equal doesn't apply to education. It was a very narrow.
Right, so
Very-
I was throwing it in now about him.
Well,
celebrating the
I
whites.
mean, it's not Korematsu better than Plessy.
I had Korematsu too.
Shima?
I was just gonna say, it kind of brings up with the Violence Against Women's Act, the Religious Freedom Act, and the Civil Rights Act. I don't think we talked about it much, but how those acts by Congress.
It was in response to the.
Response.
Yeah, in many respects, it was the Civil Rights Act, 1964, and not the Supreme Court that killed Plessy. I think that's a fair point.
Okay.
I think I may have mentioned that too. We did the Commerce Clause case, and we did the Hearts of Atlanta Hotel and the Katzenbach, the
It
Ollie's
did. It got
barbecue
rid of
case.
the people using.
It was really the statute and the enforcement power of Congress and civil litigation that killed it, not straight up, judicial.
Not judicial.
Not really.
You said it
It was 1964, exactly. That was the ban on discrimination in places of public accommodation. That's what really moved things along.
See, and I apologize. That's what I had it in my note. That's what I was writing.
That's
I said,
okay.
I believe a state can separate people based on race. Under Plessy, that's what I had. That SCOTUS upheld the Louisiana law. I guess I have it wrong. Yeah. All right. Thank you.
That's okay. Other questions? Yes, Amanda. Not at this juncture. It's too late. No, sorry. That's what we're doing now. Other questions? Going once. Yeah. If you want a minute, take a minute. I don't want to rush you. You actually managed to come here at 8 o'clock. They moved.
Okay,
Yeah.
we can use Lochner, right?
Always Lochner. What are you using it for?
I'm just saying. I don't know what. Well,
Going
that's
in
where.
there.
No, that's where the the government can say the state statute's wrong.
Yes.
What about Hamilton's the president's inherent power? 'Cause he said it, but the book says something.
I'm sorry. Say that again, please. I didn't follow what you said. Okay.
He said that the president's power is inherent.
Oh, I see what you're saying.
And the book says no. Like, can we say that it's-
I mean, in terms of historical precedent, if you're actually discussing Hamilton's views, then yeah, I mean, you can always cite anything, right? I mean, if there's something we discuss in its historical nature, and especially the question is positioning you at the time of the American founding, I mean, then yeah, you don't have much other stuff to go on. Yes.
We're in a constitution, or what we can and cannot write now.
Oh, it's entirely open book. You can remember whatever, I mean, whatever you want, you can bring. What?
You said mine. You can use the resource.
Well, if you actually read the instructions, there's anything that's printed. So as long as it's printed for, you can't bring your iPad if you're noticing your iPad. Every year, someone's like, can I bring my iPad? No, you can't bring your iPad. But if it's printed, you can bring it. You can always bring your Constitution. You can read it. I don't care. It's not going to help you. And if this enterprise, this sample has been a thing, your notes, you're not going to get the answer from your notes. I mean, maybe if you remember, oh, what was that case in the one, something to refresh your memory, but you're not going to have time to scan through your notes to answer the questions. It's going to be too hard. These questions aren't easy. They're not meant to be easy. I want a good curve. It's actually perverse, but giving an easy exam is unfair to the students because it's a curve. And if you get 1 point below the curve, you drop down to a C very quickly. So a flat curve actually doesn't benefit anyone. Other questions? Going once. Going twice. Thank you for a great semester. Good luck with the exam. We're going to have a good New Year, good Christmas, good Hanukkah, good Kwanzaa, good everything else. And I will see you all probably in January. Thank you so much. Thank you. And there were 2 people watching the stream online, so they're all slackers.